Why are they having another convention? This convention was made up primarily of bankers and lawyers. Does that tell you anything right there? They didn't like what had already happened by the people's will. So they were going to fraudulently cover it up. So they create this other constitution. And bear in mind, this is 1889. We're talking telegraphs, trains, and horse and buggy. Okay, there's not the internet, there's not great communication throughout the state. So people probably are going to be more susceptible to this kind of fraud than they would be maybe today. On October 1st of 1889, they hold a vote, and this second constitution was voted as well and approved. So,
did the people have any input?
Well, the question was, did the people have any input? I assume that there was some manner in which the people might have had input into the convening of this convention. I don't know that. I haven't researched that part. But the point that I want to make ultimately clear here is this convention violated the law as set forth in the prior Constitution. The prior Constitution had within it articles that set forth how to amend, how to repeal, how to, adjust the Constitution, and this was not followed. Because the Constitution that was done here in 1878 clearly said that no convention can be held until these offices are seated. So the first thing is to seat this government. Then if you want to amend the Constitution or call for another convention, there's a procedure for doing it. So it wasn't that the people had locked themselves out from having another convention, but they did not follow that procedure for this convention. So, here we sit. Now let's talk about style of process for a second. Style of process. Court action is a process, or it involves process. And the heading of that process gives you the authority by which the process issues. Voting takes place under a style of process. The style of process that was ordained under the Organic Act was Territory of Washington. If there was an election to be held, right on the top of the ballot it should say Territory of Washington to let you know this is the style of process. Or if you get charged for a crime, the very top of the indictment or whatever, it should claim Territory of Washington versus the defendant. That's the style of process. The 1878 Constitution calls for the style of process to be the people of the state of Washington. The 1889 Constitution calls for the style of process, that's this Constitution here, calls for the style of process to be the state of Washington. And I'm emphasizing the word the because this is actually in quotes. Article 427 is the state of Washington in quotes. The style of process that you see today is simply state of Washington. It's not the state of Washington, it's not the people of the state of Washington, it's not territory of Washington. But there was an act in 1889, in page 94. It was an act that was done without enactment clause, which is required by law. They didn't do it, probably because they knew full well this was an unlawful act. Let me read you this act. It's very short. Whenever in the laws now enforced in the state of Washington, or in the laws of the territory of Washington, as continued in force by virtue of the acts of Congress, as under the operations and provisions of the Constitution of this state, the words territory and territory of Washington shall be used. The same shall be construed to mean state and state of Washington. Now that's the key point. Let me reread that. The words territory and territory of Washington shall be construed to mean state and state of Washington. Do you see that? If I cross out territory and put state here, that's where we're at. Style of process. This is the fraud. They took the territorial offices, transformed them by this act into state and state of Washington and continued on as if we were still a territory. And the style of process simply reflects that change as modified by this act.
What is that act?
This is page 94 of the 1889 session laws. Now, this Constitution in 1878 called for circuit courts, would be the courts of record. This Constitution here called for superior courts. The territory previously had district courts, I believe. So, in 1889, the next thing the legislature did after they did this, just a few pages later, I think it's 324, I believe, in the session laws. Yeah, 321 through 325 and 341 through 346, they create two courts, a Supreme Court and a Superior Court. Now, the Constitution in 1878 created courts, and you didn't need a legislature to do anything. The courts were created by Constitution. The courts were created in this Constitution by Constitution, and you didn't need a legislator to recreate those courts. But the courts they recreated didn't have a style of process that matched up with either one of the constitutions. They had a style of process, state of Washington, as we showed earlier, modified the territory into the state and created a court system. Why? To fool the people into thinking that this Constitution created courts, and that now we had a court system that was under the Constitution. We didn't. What happened to this Constitution? Nothing. It sits in Olympia to this day. If you go back to D.C., you'll find it doesn't exist back there. You can ask the National Archivist, as I've done, to send you a certified copy of the Constitution of Washington, and you get this one, not this one. So now, back to the idea of reforming government. I want to take another rabbit trail just for a second and talk about two words, de facto and de jure. De facto is Latin for in fact. De jure is Latin for jure is law, in law. Okay. If I hold an office, say the office of president, then the office has to be established by law in order for the office to be de jure. And then I have to be appointed to that office by law in order for the officer to be de jure. But if the office itself does not exist in law, then the office itself cannot exist in fact, because the courts have ruled quite routinely. There's no such thing as an office in fact, only an office in law. Because just because you claim to hold an office, if the office itself is not created by law, there's nothing to claim to. And so going back to this situation here, if the law establishes offices under the 1878 Constitution, and if the Secretary of the Territory fails to hold an election to fill those offices, does the office still exist in law? Yes. Does the officer exist in fact? No. And herein lies the solution. How to fill an office without an election. Because that's what we're up against. Now, contrast that with the territorial offices or the offices created by statute from here forward. Do those offices exist in law? No, they do not. Because an unlawful event occurred in the creation of those offices. Now, the magnitude of that situation is extreme. You understand that? We have a whole system built upon this fraud. And here's some guy going to say, well, they don't exist in law. Isn't that the way the law works? Though the heavens may fall, let justice be done. If it's truth, isn't that true? You can check it out for yourself. It is true. So rather than try and get these offices to follow a law that they're not bound to, why not refill the offices that are lawfully created? Now, how do you do that? How does one go about filling an office if there's nobody to hold an election? Is this an insurmountable problem? No. What would happen tomorrow if an airplane crashed and all the government officials, don't get too excited, I'm just saying what if, and all the government officials were perished in that plane? Could we not then go, well, okay, you be governor, and you be Secretary of State, and you be treasurer. Could we not appoint temporary people to hold these offices totally without election? They're still bound by the office, the laws of the office. They can't go and do unconstitutional things, but they can be appointed, or they could just claim the office. Say, I'm governor, unless somebody else has a better claim. And that's the way the law works. If I claim one of these offices, unless there's somebody that has a better claim, I'm in. So that's what I did. And this is what I'm going to ask you to do. Do you want to reform this government? Do you want a constitutional form of government that operates under the rule of law? This is how you get it. I gave this actual notice to the candid world, and I claimed, whereas the office of the Second Circuit Court judge has been vacated due to a breach in the fiduciary obligations, namely the refusal to hold elections, whereas the people of the state of Washington did create the office of the Second Circuit Court judge in 1878 by voting to approve the Constitution, and whereas the people of the state of Washington are deprived of the benefits of law provided by the vacancy of said office, therefore, I claim the office. So I signed it, I had witnesses, and I filed my notice with my oath of office in the office building where the Secretary of State should reside. Now, I understand that the Secretary of State that sits there, or the guy that claims to hold that office, does not exist in law. But the building exists, in fact, and when somebody who claims the right office walks in there, they should have possession of my oath. And I also posted on the Temple of Justice. We have a judge now for the Second Circuit. Now, what can the judge do by himself? Very little. We don't live in a theocracy. We don't live in a monocracy. We live in a republic. And a judge by himself has no authority. We need more players. We need more people to step up and claim offices. We need county sheriffs. We need a governor. We need a Secretary of State. We need a treasurer. All these offices have to be filled in order to work this thing together for the people. And so that's what I'm encouraging you to do by making this DVD, is to put it in your ID, in your head, of what office you can claim, and claim it. And let's take back the offices. Now, once we have the offices filled, we can go to the federal government and lay claim upon the agreement. You see, the territorial offices, they're not going to go to the territorial offices, if they did exist, they couldn't go to the government and say, hey, we want to enforce that guarantee of Republican form of government, or we want to enforce that 10th Amendment. Doesn't apply. But if we have state government, then we can go to the federal government and say, we want enforcement of the 10th Amendment. We have an insurrection here. We need military help. And that's the job of the Provost Marshal. It's all spelled out in Title 50 of the U.S. Code. Problem is, until you have standing to approach that marshal, you'll be bounced out of the office. We need officials in government to make these claims, to make this stuff happen. I'm not advocating any kind of anarchy. I'm advocating a cease or stop of the anarchy and go back to the rule of law. Okay, questions from the audience.